And I believe the next congressman to ask questions is Mr. Jeffries from New York. Thank you, sir.
Thank you, Mr. Chair. I thank you and the ranking member. And I thank you, Ms. Pallante, for your testimony, for your service. You referenced earlier the view that copyright law exists or should exist to serve the public interest, which I think is an assessment that all of us on this committee share within the Congress. Certainly there's a constitutional prerogative that we've been charged with in that regard. Is it fair to say that in the context of promoting the public interest through the vehicle of copyright law, that one of the greatest threats or something that should be evaluated is the ability for the creative community to have its work respected and protected?
Yes, thank you so much for that question, Congressman. In other words, the other side of that eloquent statement is that people do not have a right to have whatever they want when they want it for free if it is the intellectual property of somebody else. There was a beautiful quote last year in the New York Times by some book authors and journalists who said that the reality is that it takes sometimes a lifetime of perfecting one's craft to create that great work that others come to cherish and find meaning from. And so we have to have a long view of culture, and that's one of the great things about copyright law. It has a long view of incentivizing authors, letting them benefit from their works, letting others invest in those, and so that ultimately we're all better off.
Now, in the past, piracy or internet piracy, or piracy as it relates to the work of the creative community, has been centered on unauthorized, illegal, unlawful reproduction and distribution. Is that correct?
Yes, that's correct. Now,
in recent times, that's shifted as it relates to internet piracy to illegal streaming. Is that correct?
Excuse me. Yes, that is correct.
Now, in your view, do the current copyright laws and the criminal penalties that are attendant to those laws, are they sufficient to deal with the shift in piracy that has taken place from reproduction and distribution to unlawful streaming? And if they're not, what suggestions would you have for this subcommittee and for the Congress as to what we should be thinking about moving forward to address that shift?
Thank you so much for the question. So there is a gap in current law. There are many gaps all over the law on different issues, but on enforcement, it is clear that the public performance right has come into its own as a primary way to disseminate copyrighted work. So whether you're streaming the Super Bowl, whether you're streaming music, a movie, the point is you don't always need to have a copy, and the consumer may not want a copy. Sometimes you may want to download your favorite movie and watch it 30 times. But with all due respect to the motion picture industry, sometimes you just want to stream it once and watch it. And so in that case, if there is illegal streaming happening, especially in an egregious, willful, profit-driven kind of way, how do you get at that activity if the best that you can do is go after them for a misdemeanor?
Now, another vehicle to deal with sort of the illegal hijacking of creative content is the notice and takedown process. What's your take on how successful that process is as of this moment, and what are some of the things that we should be thinking about moving forward to make sure that we have the proper mechanisms in place moving forward to deal with this issue?
Well, that is a huge question. I would say that if you go down the road of looking at the next great Copyright Act and revising the statute in a more comprehensive way, you should look at the DMCA. You should look at the efficacy of the DMCA. It's been 15 years. That's a very long time in internet years. How is it working? What have the courts done with it? Who is it affecting in what ways? So there are many, many players in the ecosystem on the internet, and I think you will hear gripes from both sides. You will hear from copyright owners, particularly small ones, that there is no way that they can keep up with the infringement happening on the web by sending notice after notice after notice, sometimes only to find that they pop up again. They're supposed to be creating. How can they possibly deal in that kind of environment? Did we have any concept 15 years ago that it was going to be this many notices, this kind of burden? However, on the other side, the DMCA was meant to be flexible and to provide rules of the road so that the internet could flourish. And I think you will find that internet actors will say there are abuses in both directions. They don't know how to deal with the notices that may not be accurate.
Thank you for your testimony. Thank you, Mr. Chair.